Hey, it's Dr. Jensen and welcome back to Module 5, Part 3. So we're going to be focusing this module on pretrial publicity and this also the next few lectures. So this will get us started, but let's jump on in. So first, we're going to talk about the jury and just a little overview of their role and kind of where that comes from. Then we'll start talking about the things that happen when your rights clash, what pretrial publicity is generally, and then again how widespread the problem is. And then we'll jump into more details in the next lecture. So the jury. The jury really comes from Amendment 6 of the Constitution of the United States, and it goes like this. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law. And this amendment was interpreted to mean a jury of one's peers, someone from your community that knows you. Then we have Amendment 7, and this states, in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. So far so good. This says, yep, we have juries even for civil cases too. So it applies to both criminal and civil. So what happens when your rights clash? This is where we get into the First Amendment challenges. So the First Amendment is that Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble, and to petition the government for a redress of grievances. This is one of the most important amendments we have in our Constitution. But when we look at Amendment 1, we need to focus on this clash that is there. So we're going to focus on the abridging of the freedom of speech or of the press. So the freedom of the press and the freedom of speech can contradict each other. We can have very strong opinions and perspectives about how involved the press should be in our lives and things we want to say about it. There are some limitations, as you probably have studied in other classes, about the freedom of speech and the press, but this is where the clash emerges. So why is freedom of speech important with the media? Because essentially the freedom of the press provides an important watchdog function to government. It gives us an inside view to start finding out what's happening, finding the truth, and then going to do those redresses of government usurpations, as we've read in many different documents, including the Declaration of Independence. So again, it provides that oversight view that is needed by the public. But why is an impartial jury important? Well, it has to do with a concept we call tabula rasa. And tabula rasa is Latin for blank slate. I have no preconceived notions of this person or the case, and I'm going in just looking at the facts and the facts alone, not being persuaded by outside influences. And then third, how might freedom of speech affect one's rights concerning the jury? Essentially, the answer is this. The reporting could taint the jury pool. So we have this function of needing a watchdog, needing to know the truth, and of course freedom of speech and expression, but all of that starts to kind of cloud over jury selection. So this gets really, really complicated where rights can clash. So when we look at pretrial publicity, or what we call PTP, this is defined as a debate between the right to a free press, which is established by the First Amendment to the Constitution, and a right to an impartial jury, established by predominantly the Sixth Amendment in criminal cases, but the Seventh Amendment in civil. So media reports of prejudicial cases relevant information. Okay, so we get this information out there, hey, this is going on. And then there also is information presented that might not be admissible at trial, but could cause a potential juror to prejudge the defendant's guilt because of the different ideas that are formed about them. So it's allowed by freedom of the press, but it's off limits as far as the court is concerned. We have a problem here. It also can cause an increase in bias against the defendant and can affect pre- and post-trial guilt judgments of mock jurors. And research has confirmed that this does happen. So we have lots of different rules that structure pretrial publicity, which we'll be talking about soon. So can pretrial publicity actually have an effect on jurors' decisions? Well, I'm going to show you a few images, and I want you to think about the first thoughts that you have when you see these images. So the first one is an image that you may be familiar with in Gainesville, where we do a lot of painting and graphic design work, the famous wall in Gainesville. This was a wall that was made in honoring those deceased of the Gainesville murders that happened in the 1990s. And there was a lot of media publicity about that locally. Well, if you're going to be a part of the jury on the trial for that defendant accused of these murders, and you see all the media coverage swelling around it, would that have an impact on your decision? What about this image? This is, to me, an unforgettable image of the Oklahoma City bombing. When you see the coverage that happened of this event, how in the world could they have selected an impartial jury who completely missed the blowing up of a federal building in Oklahoma City in 1995? So what thoughts do you have when you see images like this well before you're given a jury summons? What about this image? Kobe Bryant. Does he bring forward any thoughts or ideas about what maybe was going on in his case? Or maybe this image, where we have Casey Anthony and Kaylee Anthony, her daughter, a very high-profile media trial that happened in 2009. So you need to remember, Facebook posts, photographs, and a lot of other material was available on the Anthony family well before the trial actually happened to really influence the public's perception of them. So again, if there's media coverage of these kinds of things, and it's very pervasive in society, we definitely have an issue when it comes to trying to keep an impartial jury present. So this is kind of a comic that I borrowed from Dr. Levitt. You know, who is the jury then? The jury is basically a reflection of the TV cameras, the magazines, the radios, the newspapers, and the internet blogs that are sitting there commenting and providing information about these cases. We don't want the jury box to turn into this. That would be really bad, because then basically the media becomes judge, jury, and executioner. And that's not part of our system, because those are very, very influenced by sensationalism, by high drama, and perceptions that aren't based on the facts and the evidence. So how widespread is this problem of pretrial publicity? Well, in one study, 27% of news coverage concerning a criminal case in 14 different U.S. papers portrayed the defendant in a prejudicial manner. It was very negative. So it can taint about a third of potential jurors out there, meaning we'd have to hope that the voir dire process of jury selection fishes these ones out so that they don't come with these preconceived notions. Many defendants also claim that they cannot receive a fair trial due to pretrial publicity, and this happens all the time. So in the 1980s, when we really first started tracking this, we had 3,000 claims. And then kind of in the period after that, it increased to 7,000 claims, over double that. So it's becoming more and more prolific as people are starting to try to make sure we have a fair trial. Some cases are really much larger than others. Certainly when you saw the Oklahoma City bombing, and we have articles that talk about that, and not only this class, but some other classes I teach, there were 1,000 articles in the local paper in the following 9 months after that bombing. We can't ignore things like terrorist attacks. So how could we possibly find an impartial jury for an alleged terrorist going on out there? I mean, this is a really, really big problem, and you can see how it can impact all of us. So the research will tell us what we can learn about this problem, and this is where we're going to next in the next lecture. So we're going to focus on how we study pretrial publicity, how this publicity affects jurors' decisions, and then how we fix this problem. We're also going to talk about the roles that psychologists play in the court. So we'll be going to that next. Let me know if you have questions, and we'll see you in part 4.